that is a very essential requirement. And in the meantime, we would be discussing some relevant new practical aspects while presenting the slide, some practical insights of different situations that we would like to discuss with you all. So today we have been given the topic of Amendment Bill 25. So we all are aware that in 2016 there was a code and several developments took place in the year 2019, then 2021. And there has been several amendments in the regulation, and based upon the practical exposure, based upon the feedback of the IPA team and the IPs in the review meetings conducted by the IBBI. So we are also aware that in 2019 valuation rule was introduced in the IBC. So before that, there were several difficulties and issues, but now the lies almost very much settled by different enactments by the Honorable SCLT and cleared Supreme Court, and in few cases, the position has been clarified by the respective high courts. So today we are focusing on the Amendment Bill 25. So this bill was introduced in Lok Sabha on 12th August 25, White Bill number 107 of 25. So currently the bill is under parliamentary review after being referred to a select committee. The select committee chaired by the select committee chaired by Jagdambika Pal. You may remember Jagdambika Pal ji. He was one day chief minister of the Uttar Pradesh. At that time, we were dealing with the government in a very penetrated manner. We were handling different government projects. That's why I remember him. So it is being chaired by Jagdambika Pal ji, who reviewed the bill and submitted his report to the Lok Sabha on 17th December 25. As of February 26, the Insolvency and Bankruptcy Code Amendment Bill is pending, with the government planning to introduce a revised version in the second half of the budget session beginning March 9, 26. So the bill is being refined to improve resolution speed and strengthen creditors' rights. Actually, now having the overall view of this amendment, we have come to an conclusion that the less burden is being given to the honorable tribunals. And now the shift is being made to the creditors regime, and more
ఇది
responsibility.
ఎన్సిఎల్టీ పవర్ తగ్గించేశారు సార్ కొత్త బిల్లులో క్రెడిటార్ అన్ని బ్యాంకులు ఫుల్ జోష్.
I could not get, sir. Actually, your voice is. Your, hello. Yes, sir. Yes, sir. I could not hear. What are you telling?
నథింగ్
Hello.
సార్ నథింగ్ సారీ సార్.
Acha. Okay. So now the more responsibility and focus is being shifted on the resolution professionals. Although as of now also, the only RP is responsible for all the happenings, and whether or not the decision is being taken by the COC, we know the outcome of 19.2 application and avoidance application. In my several cases, the dissolution is going to be completed, but 19.2 is pending. So this is a brief scenario wherein more focus is being shifted now to the COC decision, to the creditors version, and honorable burden on honorable NCLT is being reduced. So that we will come across one by one over the slides. So the foundation is the thought process which ran behind the mind of the IBBI and other stakeholders was to have a consolidated law and on reorganization and insolvency resolution of the corporate persons, partnership firms and individuals. Actually, when the law is made, then partnership firms and individuals are always included. The entire law is made or entire law is amended with certain parameters. But we all know that the partnership firm and individuals are not covered as of now. So it aims for the time-bound resolution to maximize value of assets. It promotes entrepreneurship and availability of the credit. Establishes the Insolvency and Bankruptcy Board of India, which is which after taking views of several stakeholders have introduced it, and it alters the priority of the government dues, payment to the government dues as per section 53, as we all are aware. So that is a basic preamble to that. So now we are moving to next slide. Actually, my one matter is going on at NCLT also. Okay. ठीक. So key objective of the amendment is as defined in the preamble, that is for the purpose of reduction of the delays, a streamlined process with the strict timeline for adjudicating authority orders. We will see that several timelines have been reduced drastically. Maximization of value, enhance asset value recovery for all the stakeholders through improved governance, and that we will see, and ease of business out of court initiation mechanism to reduce burden on judicial system. This is what we were talking about just now. Global standards introduce cross-border insolvency and group insolvency frameworks. So that is also in line with several agreements and understanding reached by our government to the different countries, and to make law in uniformity with the similar law in other countries. Better governance strengthen oversight of the resolution professionals, liquidation and service providers, and it also ensures creditors protection, strengthen the right of dissenting financial creditors in the resolution plan. They have also introduced concept of security interest and how the value will be assigned while making distribution, how value will be decided matching with the security interest. So new definition and key terms have been used. That is section 331A, service provider. So insolvency professional agency, IU, and any central government notified person rendering service in insolvency and bankruptcy process. Actually, in service provider, now they have taken all the service providers under one umbrella. We will remember, we would be remembering that in case of any proceedings initiated against the IU or IPA or other service provider, then they were allowed to file the appeal to the Honorable Enclave. But this was not applicable in case of insolvency professionals. Now they have streamlined the law by taking all the service provider into one umbrella, and now the IPS can also prefer their appeal to the Honorable Enclave against the order of the IBBI. Previously, it was not there. We will see. Section 52A, avoidance transaction. And transaction as referred to in section 43 preferential, 45 undervalued, 49 defrauding creditors and 50 extraordinate credit transactions. So now they have included in the definition under section 52A. What is the meaning of the avoidance transaction? Previously, we were having all these different sections, but it was not, we were calling it as an avoidance transaction, but it was not defined in the code. Now they have defined it. Section 59A, fraudulent or wrongful trading as referred to in section 66, now explicitly defined for use across the code. So now in 59A, they have defined fraudulent or wrongful trading. Security interest has been clarified. Section 331. It shall exist only when it creates a right, title, interest pursuant to an agreement by two or more parties. This is very relevant for all of us. It does not include security interest created merely by operation of law, for example, statutory charges. So now they are telling that security interest shall only exist when there is an explicit agreement in between the parties. So that agreement must cover the nature and level of the security interest. Beyond that, the several other charges and other things which are included, it will not form part of that if it is not covered in the agreement. So now we will move to another slide. CIRP reform application process. So section 7, financial creditors application, adjudicating authority must admit application within 14 days. If default occurred, no pending disciplinary proceeding against proposed RP and application is complete. We all are aware that time deadline has already been prescribed throughout the IBC code, but that time deadline is applicable on the resolution professional, not to any other body, whether it is COC or adjudicating authority. But now this amendment is trying to focus on, we will see afterwards, focus on the timely decision. And if there is no timely decision, the reason has to be recorded. But the benches needs further strength, needs further strengthenment, and if it is not done, then again it will be a paper print only without any practical execution. No other grounds can be considered for rejection once all requirements are met. So the learned adjudicating authority role is now confined to 3, 4 parameters only. There is a debt. Second, there is a default. Third, within limitation. And fourth, the debt is not repaid. And RP will be appointed, we all know, if no DC proceeding is there. Record of default from information utility by a financial creditor is sufficient to ascertain default. That is explanation too. Although the financial creditors were allowed to submit the proof of default from information utility in their section 7 application, and it is also mentioned in our IBC code. But even after that, the suspended board or other parties, they were raising several issues on the loan amount, default date, NPA date, so many other things. But now the position has totally been clarified. If it is registered on the IU, then there cannot be any further question on the debt and on the default. That is the admitted position. This was mentioned in, this is already mentioned in our present IB code, but not in the way which is defined now. So proviso to subsection 4 omitted. 14 days timeline now clearly prescribed in subsection 5. Now they have made a clear provision into that. Section 9, operational creditor, board empowered to specify additional information requirement by regulation. So for that we have to wait for the regulation. Although they have given several clarifications, amendment in the present IB code also. GST बिल लगाना है और चीजें लगानी है तो वो है, लेकिन इसके लिए एक अलग से उनको amendment they have to introduce. If application not decided within 14 days, A must record reasons in writing. Ab, again, we were discussing that they will record the reason because the benches are few and NCLT are working on the contractual staff. So many difficulties are being faced. So unless and until the NCLT's benches are increased, more personals are appointed, so the position will remain same. Section 10, corporate applicant, right of corporate debtor to propose IRP abolished. तो अब जो है the corporate debtor shall not be in a position to propose the name of the RP. Previously it was there. A shall refer to board for recommending an insolvency professional as IRP. A board empowered to specify other required information by regulation. So even after NCLT referred to the board for recommendation, but board will also specify certain other requirements to be complied by the RP or by the applicant, and for that we have to wait after the bill is passed. So next, please. Withdrawal of admitted applications. Section 12A, revised framework. If RP files application, then 90% of COC approval, it is already there in the code. And NCLT review, only 30 days time window has been given. Or they may allow the withdrawal or reject it. Cannot withdraw before. You cannot withdraw before constitution of the COC. So at present the position is different, and now the proposed position is totally different. You cannot withdraw the application, you cannot file application under 12A before the constitution of COC. Now the applicant's consent, the Form FA, in which applicant's consent was also required, they were signing. Now applicant's consent is not required. At the stage of filing withdrawal application, the consent of applicant is not required, but opportunity of hearing may be given in case that party desires. And you cannot withdraw after first invitation for submission of resolution plan has been issued. If you have issued the request for resolution plan or invitation for submission of resolution plan, after that you cannot withdraw, file withdrawal application under 12A. 30-day order timeline. The NCLT must pass order within 30 days. Must record regions if delayed. Again, we have discussed, so 30 days timeline has been given. So committee of creditors, the key changes have been proposed in the COC. Now the COC role has been extended to the liquidation. Previously, what was happening that the COC role was completed on the completion of the CIRP. Then they were proposing the name of the liquidator with the liquidation resolution. Then the liquidator was being appointed, and the first SCC. Now they made amendment sometime before, that the first SCC, if SCC is not constituted by that time, then the first SCC will consist of the COC created in CIRP. So now they have specifically clarified that the COC constituted during CIRP shall also supervise the liquidation process by the liquidator. Provision of section 21 and 24 apply to liquidation under chapter 3. Board may specify additional creditor class who may attend without voting right. Means we are going to deal with two situations. One is stakeholder consultation. Second is, although in stakeholder consultation, all uh, all are the COC member barring one or two new claims we may receive. And now other creditors class, creditor class will also join the meeting, but they will not be having voting right. So for that, IBBI has to frame guidelines. Section 528, voting share clarified. Voting share based on financial debt owed only to eligible voting member of the COC. Financial debt owed to related party creditor who are not eligible to vote shall not be included in computing voting share. पहले in several cases it was seen that when we were calculating the voting share, so if the person is a related party, then we were assigning the share to different COC members considering the amount owed to that related party. So, and after that, the share was being worked out. But in no case, we were not allowing that related party to vote in the meeting. But now the specific provision has been made that while computing the share of this of the financial creditor COC, that related party amount will not even considered. We cannot consider it now. Section 22(3) deemed appointment of RP, where COC resolves to continue IRP as a RP. Such person is deemed to be appointed as RP from the date of resolution. This is a very welcome change. Previously, what were happening that the COC passed a resolution, then the application was being filed to the learned A, and after some time, say 1 or 2 months after the RP was being appointed, so after that takeover, handover, it was taking unnecessarily time, consuming time. Now it has been clarified that the RP will continue to work immediately after passing the resolution by the COC. He will be appointed as RP immediately after resolution of COC. No separate intervention by the learned A required. Decision has to be communicated to the IRP, corporate debtor, and the board. Only decision of the COC has to be communicated to the CDN and to the IBBI. Section 199, 196, standards of conduct for COC. IBC empowered to specify standards of conduct for the committee of creditors and its members while acting under Part 2 and Part 3 of the code. We may remember that the IBBI has already came out with the guideline for the COC that how to act, how to perform, how to decide on different resolution in the IBC process. Unfortunately, that guideline is not followed in totality, and we are facing different challenges, delayed decisions, and extension of voting line again and again, again and again. where the law prescribes that we can give extension only once and not three, four, five times. So uh, now uh, the law prescribes that the IBBI shall specify the standard of conduct. And we are of the view that if IBBI specifies and it comes in the IB code, previously they have specified, but it was not a part and parcel of the IB code, hence it was not viewed seriously by the COC members. So now if it is taken in the IB code, then definitely it will have a very great revolution in the IBC, and we would be facing less challenges in doing our work. So, updated duties of the RP has been updated. Section 18 claim collation and verification. IRP must verify claim while collating them. So, ये तो हम लोग करते ही हैं. If required, IRP shall determine value of verified claim. हाँ, ये एक important चीज है. Collation is an act wherein we gather information and without application of any extra mind, we have to collate and then admit it. Now they have said that our IRP shall determine value of verified claim. So now we have to determine the value of verified claim also based upon several parameters, and for that purpose board will specify the manner of collating claim. So there would be a complete set of guideline how the claim would be collated. So that is there. Section 25, filing applications, extended duty. Duty to file application under Chapter 3, avoidance transaction, now extended to also cover fraudulent or wrongful trading under Chapter 6. सो अब क्या किया है कि हम लोगों की ड्यूटी को इनलार्ज कर दिया है. क्या व्हाट enlargement has been given to it? Duty to file application under Chapter 3 now extended to also cover fraudulent or wrongful trading. So previously we were bound with our duty to file application in avoidance transaction. Now it is avoidance means preferential and other transactions. Now we are duty bound to file application in case of fraudulent or wrongful trading. New definition, avoidance transaction and fraudulent or wrongful trading is inserted in section 5, which we have discussed earlier. So now the complete definition has been given in the law. Section 19, cooperation, broader scope. Scope expanded from personal promoter to also include persons associated with management and those engaged in contract for service. So this is very good. Previously, we were filing application against the government department because the law prescribes that we can take information from the government department, from the management, from other authorities in the CIRP process. But and also the auditor and the financial consultant, they were also covered. But now they have enlarged the scope, and any person who is associated with the management of the company and those engaged in contract for service, any type of contract means any type of contract and not only the financial or other contract. So any type of contract they are covered, so we can take information from them also. Provision apply to both IRP and RP. ठीक है. Learned A can direct any related person to also cooperate. If any person is related, then we may demand documents or information from them. In case they are not providing, we may prefer application to the learned A for issuing necessary directions. Non-effect principle expanded. Filing application in respect of avoidant transactions or fraudulent trading shall not affect CIRP or liquidation proceeding. So, generally, whatsoever is going on in today's CIRP also, if CIRP is completed and avoidance transaction application has been filed by the RP and same is not disposed of, then presently the successful resolution applicants, mostly they were taking the responsibility to take care of those applications, and the recovery proceeds, the distribution mechanism of recovery proceeds arising out of avoidance transaction application was properly narrated in the resolution plan. So mostly it was going to the financial creditors. Now they have specifically clarified filing application in respect of avoided transaction or fraudulent shall not affect CIRP or liquidation proceeding. So that proceeding has been kept distinct from the CIRP or liquidation proceeding. Completion of CIRP or liquidation does not stop these proceedings. Meaning, previously it was not there, although the same practice was being followed by the RPs and the learned A also. The same practice was being followed, but now it has been specifically clarified and mentioned in the law. Key reforms are there in the resolution plan. New minimum payment threshold. Payment to descending FC shall not be less than the lower half. So there was a several dispute with respect to the dissenting shareholder, dissenting stakeholder COC member, and there had been variety of judgments by the honorable NCLT, different benches. So now they specifically it has been mentioned that payment to descending FC shall not be less than the lower half amount payable in liquidation under section 53. Previously, it was only amount payable in liquidation. And now, amount if distributed as per section 53 priority from resolution plan distribution. So, this has been inserted. The one was there, two has been inserted. So, shall not be lower of the following. So, that has to be considered. Section 32 2D Implementation Committee. Each resolution plan must now provide for the constitution of a committee to oversee implementation and supervision of the approved resolution plan. Previously, the same was not present. We were having monitoring committee. The resolution applicants were proposing monitoring committee, and that monitoring committee in few cases were having RPs and few cases were not having. So that committee was consisting of the resolution applicants representative, financial creditors representative, or some other independent person or RP. And in one case, if you could remember that the RP was the chairman of the monitoring committee, and his remuneration was fixed. He took remuneration, uh, and on that ground he was suspended by the IBBI. That you undertook the salaried employment. मतलब this understanding was made. How it becomes salaried employment, I don't know. But that was a phase wherein that monitoring committee was supervising implementation, and when all the payment, everything was complete, then the powers and assets were transferred to the resolution applicant. Now they have clearly defined the implementation committee, and now it is must to provide in the resolution plan. Section 32D restructuring expanded. Resolution plan may now include sale of one or more assets of the corporate debtor in addition to merger, amalgamation, demerger. We may refer section 37, regulation 37 of the CIRP regulation, if I am naming correctly. So that I would like to mention to our friends. So regulation 37 of the CIRP regulation, which provides that the resolution applicant may provide for transfer of all or part of the asset of the CD to one or more persons. So that is already there. Sale of all or part of the asset, whether subject to any security interest or not. Restructuring the CD, the substantial acquisition of shares of the CD, so satisfaction or modification of security interest. So that is given in regulation 37 of the IB code. But it has been clearly provided in the IBC code, IB code. Previously, it was in regulation. Now the code has been amended. So, for example, if any SRA is taking 3-4 assets, then he may propose in the resolution plan that he will dispose 2 assets, and by that, with that proceeds, he will pay up the debt of the FCs. So that is good. If some assets are there with the CD, which are not directly connected with the business, then it may be disposed and may be used in the resolution plan. Stacked approval. A must first approve implementation, then separately approve distribution within 30 days. That is a very important thing which we must note it. Previously, what we were doing, that immediately after receipt of money, we were making distribution to different stakeholders as per their percentage share. Now, the when SRA is there and the resolution plan was being approved. Now, what is there? A may first approve implementation. So, whatsoever implementation proposal has been made in the resolution plan, that may be approved by the A first, and then when the plan is implemented, means we have received the funds from the SRA, then naturally we will make distribution. So distribution has to be approved separately by the learned A with the approval of COC. So that is a completely, this is a major shift. 30-day order timeline. A must pass approval rejection order within 30 days of receiving resolution plan. Must record reasons for delay. So again, the responsibility is already there in the present IB code. That order must be passed in 14 days, in 30 days. It is already present. But as we are saying that practically it is not possible. So for that, a high level of revamp is required at the NCLT if we want to have timely order. Defect rectification. Before rejecting, the learned A may give COC opportunity to rectify procedure defect in the resolution plan. Previously, what was happening, that for the minor defects, or for example, the mandatory contents of the resolution plan, if something is left out, or a technical and feasibility report is left out, the plans were being rejected. So now it has been clearly provided in the law that learned A has to give opportunity to the COC to rectify procedure defects. CCI, Competition Commission of India, approval timing. So there had been a lot of debate on the CCI approval, because if a CCI approval is not there and resolution plan is approved, then it will not uh, get the finality because of the CCI pendency. Or if CCI approval is not there, the plan cannot be implemented successfully. So now they have specified the timing. Back career slide, please. CCI approval for combinations required before submission of resolution plan to the A, not before COC approval. So there was a very famous case law. Right now, I am not remembering that case name. But in that related to CCI approval, there has been a lot of debate, and after that, the law was amended, and they provided that CCI approval has to be taken before the COC approval. So now they have substituted it. It is required before submission of resolution plan to learned A. The clean slate principle, section 31 and 5. Once a resolution plan is approved, past liabilities are extinguished. The corporate debtor gets a fresh start. So that is already there in several resolution plan on the date of approval. Section 30 A. Yes, section 30 A2 is there, which specifically provides for that. But now they have made uh, amendment, because what successful resolution applicants were facing, that after approval of the resolution plan, the licenses, permits, registration, quota, so the authorities were asking them to pay the old dues, then file a new application, and clear every outstanding liability. Only then the same will be continued. Otherwise, license, permits, registration, whatsoever is expired earlier, then it is expired. Naturally, they have to apply, but they are not required to pay the old dues. So, subsection 5, it grant protection, license, permit, registration, quotas, concessions, and similar grants shall not be suspended, terminated during subsistence of remaining period. तो ये जो है नहीं कर सकते, अब कोई गवर्नमेंट अथॉरिटी नहीं कर सकती. अप्लाइज वेयर कॉर्पोरेट डेटर और रिजोल्यूशन अप्लीकेंट कंप्लाइज विद रिमेनिंग ऑब्लिगेशंस. अगर कोई रिमेनिंग ऑब्लिगेशंस हैं, फॉर एग्जांपल कि किसी लाइसेंस की फीस, इफ इट इज 1 लाख रुपीज एंड 80,000 हैज ऑलरेडी बीन पेड, 20,000 is remaining, then you pay it and it will be continued. Binding on central, state government, local authorities, and sectoral regulators. So it is binding on all that we discussed. Subsection 6, claim extinguishment. All claims against a corporate debtor and its asset not in resolution plan are extinguished on approval. ठीक है. The similar situation is present right now also. No proceeding shall be continued or instituted based on such claim. कोई proceeding कुछ भी नहीं चल सकता. Does not affect claim against promoters, guarantors, joint ventures, several liability persons. It will not exclude the approval of resolution plan, will not exclude any claim against the promoter, guarantor, and other persons who have been associated. Criminal liability is already excluded. We all know it has no correlation with the IBC, IBC, and uh, other liabilities, if any. If third parties have filed some court cases against the promoter, and directors. So that will continue. Right of indemnification from corporate debtor is also extinguished after plan approval. So that is there. Certain few terms have been added in this new definition. So that we have to see. Uh, uh, Please allow me 2 minutes break. After that, we shall be joining. Thank you. Yes, friends. So, so should we start? Okay. Thank you.
Yes, please start.
Thank you. Thank you. Thank you, sir. Thank you. So the most significant new concept and out of court insolvency initiation mechanism for genuine business failures. This is what we discussed at the start. Now the focus has been shifted to the creditors and the RP with the minimum intervention of the honorable adjudicating authority. Now, who can initiate? Financial creditor belonging to a class of financial institution notified by the central government. Minimum default threshold section 4 must be satisfied. So, in the proposed bill or by way of notification, the minimum threshold is also being looked into. When the new bill will be passed, we may also see changes in the minimum threshold. So, in this new era of insolvency, so they have defined that who can initiate belonging to a financial institution notified by the central government. So, for that notification has to be there. Management stays. The management remains with the board of directors partner during the process. पहले क्या था कि immediately after our appointment, all the management rights were enjoyed by the RP, IRP or RP, and they were controlling the entire business gamut of the CD. Now it is not there. Now the management remains with the board of directors or partners during the process, unlike CIRP where management is displaced. So this is the second thing. First we discussed specified financial institution fulfilling the minimum threshold may apply. Second, the management will remain with the board of directors, not with the RP. Out of court start, process commences from the date of public announcement by resolution professional. No court order required for initiation. ये इनिशिएट हो गया जब पब्लिक अनाउंसमेंट आपने इशू किया तो ये प्रोसेस रिजोल्यूशन प्रोसेस स्टार्टेड नॉट CIRP converts to CIRP. Now this process is converted to CIRP when if resolution plan not achieved or conditions not met, automatically converts to full corporate insolvency resolution process. तो अब इसको जरा एक बार ठीक से समझ लेते हैं फिर से क्या हुआ कि एक ग्रुप ऑफ फाइनेंशियल क्रेडिटर fulfilling the minimum threshold will initiate the process and will appoint RP, IRP, RP that we have to see in the amended code what they designate. Management will remain with the board. So RP will issue public announcement. By this time there is no NCLT. NCLT role is not there. You have to issue public announcement. The process is started, resolution process. You will do all the processes which is prescribed in the IBC law. All process means expression of interest, invitation for the resolution plan, selection of the resolution applicants, constitution of COC, each and every activity whatsoever has been specified in the code, you have to do that. And till then, no LCLT is there. You receive resolution plan, then you file it to the NCLT. And if the resolution plan is not fit as per insolvency and bankruptcy code, or conditions of the resolution plan are not met, then it will convert to the full corporate insolvency resolution process. Then it will be there. Shorter timelines, 150 days for completion, extendable by 45 days, much faster than standard CIRP 330 days. So by way of amendment 4 years or 5 years back, the law has prescribed that CIRP has to be completed in a maximum period of 330 days, including your litigation period also. So, although the practically it could not be achieved, and the honorable benches are giving extension based upon the situation, case to case basis. Now only 150 days you have for completion, and it is extendable by 45 days only once with a proper problem you faced, or why you want extension, that has to be clarified very clearly. Eligibility was not available if ongoing CIRP liquidation proceeding exists, or if any insolvency process completed within past 3 years. So the initiation cannot be done if ongoing CIRP liquidation proceeding are going on, or if any insolvency process completed within past 3 years. That is there. Section 58B, initiation procedure.
Can you go back to the previous slide, sir?
Okay.
What could be the intention behind this? Any explanation here? Like, why would they think about such a new chapter? What is the benefit of this?
Actually, as we discussed earlier, that right now, we are facing pendencies at the learned A. So we constitute COC, then we file it to the Honorable NCLT. Then CIRP initiation order is there. Then initiation is done after a long period of time. If the section 7 or 10 application or 9 application is filed, then it is admitted after a long period. So it also wastes time of the financial creditor and other stakeholders. So they have curtailed all these things, and now the entire power has been given to the financial creditor. They will appoint RP, he will start the process, he will do the resolution, and resolution plan will be filed. And if it is not met or it is not converted to the reality, uh, then the CIRP will start. And now in that CIRP, only work left out is to again invite for the EOIs and then proceed further. So this is the process to curtail all these timelines, which are NCLTs are overburdened. So responsibility has been given to the RP and to the specified notified financial creditors.
And
Sir,
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 class
in this case,
meaning, can you give some example of class of financial creditors? I mean, financial institutions.
Financial institutions, so they will
Class of financial institutions, like for example,
yes, yes, it will be yes, it will be notified by the central government after the bill is passed. But as far as our understanding is concerned, it will include all nationalized banks and other financial institutions. It will not include NBFCs and all other things, but it will include the financial that banks and other financial institutions.
So that
The
means
same.
sorry, sir, they should be coming as a group, is it?
Yes. For example, if what is there, that if for example 2 3 lenders are there and they are within the definition of the notification issued by the central government, so they will collectively decide and they will initiate or we have to see in the amendment bill what is exactly amendment when it is passed, because it is under scrutiny at the ministry right now. After the recommendation of Jagdambika Pal, certain recommendations have been given. So if one creditor who is having, for example, who has granted loan, if he initiates, then other will also join him, because they have to file claim to the RP. So one initiated and the claims has been filed to the RP, then RP will constitute the COC and he will upload to the IBBI. It is not required to
sir,
be filed to the. Yes.
sir, there are two, three things here. One is that, I think the jurisdiction of NCLT has been removed, in terms of filing CRP applications, and NCLT used to order. So that leaves up to the. So when you say that, that financial creditors would initiate the COC, initiate the CRP, what does it mean? They would not go to the NCLT court. They will not have any jurisdictional backup in terms of executing the CRP
Yes.
process.
Yes. Yes.
Now
Yes.
this may lead into practical problems. Any financial creditor can appoint a IRP or CRP process, initiate it, and put pressure on the management and the T. Point number one. Point number two: if the management stays, then that means the same practices would remain which were there before, and IT responsibilities increases multifold in this case. he would
Yes,
be, you know,
that is there. Yes.
he would be subject to those his judicial or his jurisdictional prudence, as well as, you know, he would be subject to management pressure. So, and the poor fellow, if the management stays there, then that fellow will have no say in the system, because the system is accustomed to working with the management, right? So I'm not sure. Yes, where the intention seems to be that, you know, okay, fast forward the things, remove the NCLT, बार बार NCLT आना पड़ता था हर चीज के लिए, ऑर्डर लेने के लिए, वो हटा दो. लेकिन वो पर्पस कितना सॉल्व होगा in real sense, you know, is has to be seen, you know. I mean,
इसके
I have my own doubts. IPs would have tremendous responsibilities for execution in these cases, and the intent seems to be that the government is, I mean, they want to rely upon the wisdom of IP, who's a qualified professional and experienced by this time, you know, with the laws and already in place for last 5 6 years. But reality may IP's guys would be more miserable. IP's life would be more miserable in the process, because, you know, one side there is a judi- judicial or jurisdictional jurisprudence which will put him in always in a different track to follow a certain process. The other side, management would have a different ambitions, or, you know, they will have.
let me clarify. Let me clarify. What is there that presently we are having a set of our responsibilities, duties, and powers. So once this will be introduced, this will be passed, then there will be a set of guidelines for the management, for the RP, and for the financial institution also. There will be a set of guidelines ki how the process has to be done. What would be
Yeah,
done by the RP, what would be done by the management, what would be done by the financial institution, and
yeah,
and we have to complete our process as per IB code. Actually, what is there? We have to complete the process as per law, and only thing is that again and again we were approaching to the NCLT and other things. For example, that you require certain document. Now the management remains with the board of directors partners. So here the view is, previously immediately on filing the application, board was raising objection, suspended directors. Then there was a reply rejoinder, unnecessarily 2 3 years were lagged on in this process. So now what was thought, let us give a chance to the board, the existing board of director, to revive his company by taking all proper steps, and all proper steps, but under a set of guidelines which would be issued. Definitely it will be issued. And that we have
yeah,
to, there would be
yes.
clear cut guideline. There will be no ambiguity into that. So it will not left open ended कि ओके जी आपको
हम्म.
समुद्र में फेंक दिया और आप खुद तैरो, ऐसा नहीं होगा. तो
नहीं
देयर वुड
सर,
बी,
वो उसमें ना, पहले के सिनेरियो में क्या है कि उसमें जुडिशियल जो बैकिंग होती है ना आईपी के पास, दैट इज वेरी मच इंपॉर्टेंट. You
नहीं
know,
नहीं
then
वो
there's
सर अभी
always a
भी है.
fear of there is a fear of NCLT. There's a fear of NCLT
सर सर
that, you
सर
know.
वो सर वो अभी भी है. अगर आपको IRP RP को इस प्रोसेस के दौरान कहीं भी कोई डिफिकल्टी होती है, तो इट हैज बीन लेफ्ट ओपन
नहीं,
फॉर द RP टू
that
फाइल एप्लीकेशन
the,
इमीडिएटली.
the that
दैट
that
इज
way
नॉट
courts are
क्लोज.
there. You know, that way
हाँ,
courts are, RP has a right to approach courts. That's right. You know, but, you know,
यस.
anyway, we'll have to see how it works. You know, I mean, these are quite early
नहीं,
apprehensions. You know.
we are of the view because 150 days timeline has been given, and into
Uh,
that we have to complete. And if it is converted to the final CIRP and moratorium is introduced, then again 150 days are there to complete the process. So the view of government is that let us give a chance to the existing board to revive their company if they can.
अभी इसमें क्या बोले, ठीक है, okay, let's see.
Yeah. And in case of any problem which we face, we may definitely approach to the NCLT. अब
Right, sir. Thank
प्रैक्टिकल
you.
जब सब गाइडलाइंस वगैरह आ जाएंगी ना सर, तब बहुत अच्छी क्लियरिटी आ जाएगी इसमें.
हाँ, वो उसी का इंतजार करना पड़ेगा.
जी 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 जी. वो एक्ट पास होने के बाद ही आएगा. अब 9 मार्च को 9 मार्च को दे आर प्रेजेंटिंग इट टू द एक्ट पास होने के बाद ही आएगी, लेकिन आएगी जरूर, आएगी जरूर.
चलो, let's see.
Yes, sir. Yes, sir. Next slide. Initiation procedure section 58B have been introduced. Initial approval. Obtain approval of 51% by value of notified class of financial institution creditors. So, if two or three financial creditors join, because in the balance sheet, the persons who have given loan are clearly identified. And for example, I am State Bank of India, and I want to do that. So I have to gather information ki which other financial institutions have given the loan. I have to organize my joint lenders meeting, and in that we have to get approval of 50% by value. So this is the first step. Notice to corporate debtor. Then after that we have to inform corporate debtor of intention to initiate and give 30 days to make representation repay default. So after taking first step, so we will notify to the corporate debtor that we are going to initiate the resolution process, and we will give them 30 days time, either to make representation or they may also pay the default. Consider representation. Third, review representation received. If pursuing initiation obtains fresh approval of 50%, 51% by value within 30 days of receiving representation. After receiving representation, the same will again be presented to their joint lender meeting, to their own committee, and they have to take a fresh approval for the initiation. And then the RP will be appointed. The appoint insolvency professional as RP. After that, he will be appointed, and then RP will make public announcement. Process deemed to have commenced from the date of announcement. Communicated to AN board. We have to file a communication only to the board. बोर्ड में तो हम लोग करते ही हैं अपलोड, और ए को कम्युनिकेट करेंगे. वी डोंट रिक्वायर एनी डायरेक्शन फ्रॉम द लर्नड डे ऑन दैट. इट विल बी टेकन ऑन रिकॉर्ड only, so that in their record it is there ki process has been initiated. So this is a brief, very brief note I have prepared, not in a very elaborated way, so that we may have a complete insight of the amendment. Next. Creditor IRP, process management, section 58D, timeline has been defined. So 150 days from the commencement date. When it will commence? From the date of public announcement. And 45 days extension we may take with reasoned reasoning. And A passes conversion order if plan not achieved within deadline. So if there is no resolution plan, or resolution plan is received, but it is not as per the provisions of IB code, or it is a conditional resolution plan, and all these things have to be done by the RP. And if it is there, then it will be converted to the full-fledged CIRP. 58F management. Board of directors, partners retain management during that process. RP attends all board and members meeting. RP can reject resolution passed in the meetings. This power has been given. We have to wait elaborated guidelines. So for that purpose, promoters must provide information for information memorandum to the RP. So promoters are required because as I told that RP has to do all the activities narrated in the law. He has to prepare information memorandum. He has to constitute COC. He has to issue EOI, RFRP. Everything he has to do. So section 58 E RP duties call for claim submission, prepare information memorandum, prepare compliance report. Section 29A compliance report has to be prepared by the RP, file report documents with the board. Here learned A is not here till that time. Only documents have to be uploaded to the IBBI portal. For that, they will make amendment in their portal and everything. Section 58G moratorium. RP may apply 5 moratorium to learned A with COC approval. Now, during this process, there is no moratorium actually. But if RP is viewing that something fishy is going on or some alienation is possible, then with the approval of COC, he may apply to the learned A that to declare the moratorium. Moratorium will commence from the date of application, not from the date of order. So this is a very important thing which we have to note. Immediately on filing the application, the moratorium will start. A confirms if moratorium is necessary for proper conduct. So learned NCLT will decide on that. Applies during entire creditor IRP period. So this is what it is termed is the entire creditor IRP period. So this is the creditor IRP period, and once this section 58D time conditions are met, when A passes conversion order, then it becomes the full-fledged CIR. Creditor IRP, objection and conversion. Section 58C, corporate debtor objection. File to A within 30 days of commencement date. If the corporate debtor is having any objection, then they may prefer application within 30 days of the commencement date. A passes order within 30 days of received. A outcome. No default occurred, void ab initio, process cancelled. Now we have to understand this. What is there? That the creditor initiation started. The 30 days time is given to the suspended board either to repay or to file their representation. Then again meeting will be called, and by 51% of vote and by 51% of vote, they will start initiation. And even after this, if the representation of the suspended board is not considered properly, or if his certain aspects are overlooked, then he may file application within 30 days to the learned A. If learned A sees that practically no default has occurred, then learned A will cancel the process. Now learned A concludes that default has occurred, but procedure has been violated. Then learned A may convert to CIRP. If learned A confirms that default occurred and no procedure violation, then the process will continue. Learned A cannot consider any ground other than default existence and procedure compliance. That has been clearly mentioned in this, that learned A cannot consider any other ground other than default existence and procedure compliances. And three aspects have been given in that particular section 58C. Section 58H, conversion to CIRP. A mandately converts when it will be converted to CIRP mandately when no resolution plan received within deadline. Point 1. Second, corporate debtor personnel fail to cooperate. अब पहले क्या था, हम लोगों के तो कई केसेस में भी फाइल्ड एप्लीकेशन अंडर सेक्शन 19 टू ड्यूरिंग CIRP and now filed application for dissolution, that 19(2) is still pending. So now they have clearly mentioned कि मत करो cooperate, हमारा प्रोसेस ही कैंसिल हो जाएगा. resolution plan rejected by the learned age. तो इन 3 कंडीशन में से कोई एक भी कंडीशन पूरी होगी, then it NCLT has to convert to the CIRP mandatory. On conversion order, A shall convert process to CIRP under Chapter 2. Decide stage from which CIRP commences with COC recommendation. अब during creditor insolvency process, we would have completed several processes as per IB code. So now the honorable tribunal with the COC recommendation will decide कि किस स्टेज से CIRP शुरू होगी, from which stage this CIRP will start. ये ऐसा ना हो कि again we have to run the previous processes which we have already completed during creditor resolution process. Appoint current RP as IRP or RP for CIRP. Appoint कर सकती है. Declare moratorium under section 14. Include creditor IRP cost in the CIRP cost. Insolvency resolution process cost. The group insolvency concept is being debated for a very long time in our professional fraternity. If 2-3 companies are have defaulted their loan, so instead of filing separate applications to the NCLT, it's better that group insolvency has to be introduced, and a new chapter has been added. Section 59A. Central government empowered to prescribe the rules for coordinated insolvency proceedings for corporate debtor forming a group. So again, the central government has to declare the rules for that purpose. For that, we have to wait. Common bench. Designation of a common NCLT bench for all group insolvency proceedings. Transfer of pending proceedings. For that purpose, for group insolvency, a specified bench is proposed, who will only see the group insolvency applications. And if any application is pending in any other court, they would be transferred to the common bench. Combined COC. Formation of a combined committee comprising COCs of all corporate debtor in the group. ये आप देख लीजिए. The combined COC shall be formulated of all corporate debtor in that group. So combined COC formation has been done. Coordination between COC, IRP, RPs and liquidators of corporate debtor within the group. So a coordination committee is also proposed who will coordinate in between different persons. Binding agreement providing measures to coordinate proceedings, binding on all approving corporate debtor and their COC. So group coordinator, appointment of a common insolvency professional to facilitate coordination across group entities. So in this, a group coordinator being insolvency professional shall be appointed separately. Cost treatment. Framework for treatment of cost incurred in coordinating insolvency proceeding across group. So that framework will come. Generally, it will be uh, based upon their share in the group. So, but for that we have to wait for the uh, guidelines after the enactment come into force. liquidation process. So there are certain major reforms in the liquidation process also. Section 33, moratorium extended to liquidation. Moratorium under section 14 1A and C now extend to liquidation process. No suit shall be instituted or continued without leave of learned A. A also appoints a liquidator in liquidation order. So if previously, right now we are having section 35. If liquidation order is there, so moratorium is there in liquidation also. But now they have said that moratorium will extend to the liquidation also, which was introduced in the CIRP. So dissolution without liquidation. It is a very welcome step. Actually, several benches, in several benches, we were facing very huge difficulty that, for example, during CIRP, the CD is having nil asset. Nothing is there except certain rent advance. So we all know that it is never recoverable. So now the COC was unnecessarily facing cost because entire process has to be run. We have to float EOI and then RFRP, then everything. Then we were going to the NCLT and telling that we could not receive any resolution plan. So now liquidation has to be. During liquidation, we have to complete the process, then file the dissolution. And if we were filing dissolution during the liquidation without completing the liquidation process, then there were objections, although Honorable and CLAT in 2-3 cases have specifically passed the order. If there is nothing with the corporate debtor, no assets are there, nothing is there, and COC is not ready to bear the further liquidation cost, immediately application for dissolution has been can be filed. So, but the position was not clear as per law. This was made clear by the Honorable and CLAT, but it was not clear in the law. Now, the law itself has provided COC can resolve to dissolve corporate debtor without full liquidation if no meaningful recoverable assets. A passes dissolution order within 30 days of receiving intimation. So we have to intimate. Intimation means we have to file application for that purpose. New liquidator replacement. New provisions. COC can replace liquidator during liquidation. May apply to A, who appoints a new IPS liquidator if no pending disciplinary proceedings. I think it is it has already been amended in the present law also. So CIRP, previously it was not there. CIRP restoration option. COC can apply with 66% vote to restore CIRP before liquidation order is passed. It is the liquidation application has been filed, and there is certain new development during that period. For example, some settlement is going on, or if some investor approaches banks or the RP that he is ready to take. So COC may resolve and may approach the learned A that they want again to restore the CIRP and don't pass the liquidation order.
Sir, can we get the case now? Just now you mentioned that CD can be dissolved without going to liquidation
Yes,
process.
yes. This is
So
this
can you
is
share, please?
this is our case only. So, ma'am, I think
No, I'm also handling the same matter, so I just want your
no.
help to.
I am telling, sir. I am telling. The ICSI madam is there. I will request her. We will share the copy of order and request her to share it to all the participants. We
Thank you
will
so
share
much.
you two orders.
Thank you.
So,
Thank you.
Kamal, kindly note it down. There is a very good order of the Honorable and Clerk. And
Right, sir.
one order is belonging to our one case. So, Kamal,
Okay. Okay.
Yes, sir. I have noted, sir.
so kindly share orders so that our friends may get it.
Yes, sir. Yes, sir.
Thank you so much. Much obliged.
Thank you. Liquidator appointment reform. COC proposes liquidator with 66% vote, either existing RP or another IP. Board confirms the appointment, RP disqualified. This is similar to the existing provision. Liquidation timeline. So earlier, we were required to complete the liquidation process within a year. Now they say that the liquidator must completely liquidate asset and apply for dissolution within 180 days. Now the period has been must. The word is must, means not for we are previously we were completing it within a year. Now it has been reduced to 180 days. Extension possible for up to 90 more days with sufficient reason. And after that, only 30 days are given to the learned day to pass a dissolution order. So this is a very challenging work for all of us. We have to be very fast. Immediately we have to do auction, and now the auction can also be done with the IBBI notified portal only. So kindly keep in mind, because there should not be any violation. The IBBI is notified a portal, name I am missing right now. So through that portal only the auction processes has to be completed. Kamal, next slide. This is the distribution mechanism under section 53. I don't find any major shift into that. The although my the friends may see, but I am not finding any major shift. Whatsoever is present as on date. At first of all, the insolvency resolution process cost and liquidation cost has to be met. Then workman dues of 24 months plus secured creditors on pro rata basis have to be made. Then employee wages 12 months, unsecured financial creditors, then government dues. Yes, this fifth and sixth is important. Kindly note it down. Fifth is government dues 2 years preceding liquidation commencement date. And remaining government dues plus other remaining debts. It is on sixth. So we have to classify government dues into two categories. The government dues 2 years, within 2 years preceding the ICD, LCD, liquidation commencement date. And the second part is remaining government dues plus other remaining debts which are out of 2 years coverage period. Then preferential shareholders, then equity shareholders. So only I find a change of fifth and sixth. So I think that government dues have been kept at fifth category, and they have bifurcated it into the fifth and sixth category only. The avoidance transaction, there has been enhancement in the framework. Section 43, preferential transactions. What changed? Look back period now starts from initiation date, filing date, instead of insolvency commencement date. Ending on commencement date. Related party 2 years, other 1 year. पहले क्या था कि the look back period was 2 year, 1 year from the admission date. Now it is from the initiation date when the application is filed. So related party, the look back period is 2 year, for others is 1 year. it is almost same. As of date, only initiation date has been changed. Section 50, extraordinate credit transactions. Look back period 2 years starting from initiation date and ending on insolvency commencement date. Previously 2 years before commencement date only. So the initiation date has been inserted. 45, 46 undervalued. Similar changes. Look back period starts from initiation date. Section 49, transaction defrauding creditors. Property acquired from a related party of corporate debtor. Now also excluded from protection. Yeah, this is a very important change. Prevents corporate debtor from hiding assets via related party chains. So it is a very great thing that although previously also currently also we were identifying that related party transactions chains, and by way of our transaction auditor report or forensic audit report, we were notifying filing application to the learned AA for that purpose. Now the duty has been cast on the corporate debtor and the suspended board that if you hide, we shall be coming on the penalty and prosecution proceedings also. If you hide, then it will be there will be a huge penalty for that if it is reported by the RP to the learned A. So now you cannot prevent, you cannot hide those transactions. You have to disclose. The corporate debtor has to disclose. The suspended board has to disclose it. So that is a welcome change. Creditors' rights under section 47 revamped. So at first of all, let us read section 47 for proper understanding. I am reading it. A small portion I will read. The present is where an undervalued transaction has taken place and the liquidator or the resolution professional, as the case may be, has not reported it to the adjudicating authority. A creditor, member or a partner of a corporate debtor, as the case may be, may make an application to the AA to declare such transactions void and reverse their effect in accordance with this chapter. This is the present provision. ठीक है कि in case the RP or liquidator fails to report the undervalued transaction to the learned A, then the creditors or others were given right to file relevant application. Now section 47 has been revamped to cover all avoidance transactions. Now all transactions have been covered. Previously, fraudulent, wrongful trading were not covered. Now everything has been covered into the definition under section 5. Preferential section 43, undervalued section 45, extraordinate credit section 50, and fraudulent, wrongful trading under section 66. Creditors individually or jointly member partner can all apply. A can pass orders as if filed by liquidator RP under relevant provision. अब इसमें एक इंपॉर्टेंट चीज है, क्या है? In such a situation, learned A may order IBBI to initiate disciplinary proceedings against delinquent RP liquidator who had information but failed to report. This has been added. Learned A always passes order even if the provision is not there for the small faults or small issues. The matter is being reported to the IBBI even for the procedural lapses. Now when the specific section has been amended, to incorporate such provision, then definitely it will be reported. So we immediately after joining, we have to analyze all the balance sheets. If balance sheet is not ready, we have to get it ready with all qualifications. If proper data is not available till the insolvency commencement date, detect the transaction, appoint the transaction auditor, and immediately report it to the without failure. This standard practice has to be opted, or if you feel that there is no asset, nothing remains, everything has gone, only SFA asset is there, then also, even if any type of asset is present, you please adopt this process. Immediately appoint a transaction auditor or forensic auditor, whatsoever you and your COC feels, and report everything to the COC, and then immediately report to the learned A. Otherwise, we may face problems into that if we fail to do this. Next, secured creditors in liquidation, section 52. 40-day deadline to inform liquidator. Secured creditor must inform liquidator of intention to realize security interest within 14 days of liquidation commencement date. If fails to inform, security interest deemed relinquished to liquidation state. So previously that as per my memory, I may be wrong also, otherwise I have to refer regulation, that days of deadline was 30 days, and now it has been reduced to 14 days. Kindly see the relevant regulation. Contribution to cost, section 52(8) amended. Secured creditors relinquishing outside liquidation must deduct and transfer to liquidator. This has to be who has sold asset outside the liquidation process. So they have to pay to the liquidator CIRP cost, liquidation cost, workman dues under section 53 1B1. This workman dues was not there previously. IRP cost, liquidation cost was there. Ensure workmen are protected even when secured creditors stand outside. So this workman has been introduced to protect their interest. Multiple secured creditors rule. Where multiple secured creditors have security interest over one asset, no single creditor can realize security interest unless agreed by creditors representing more than 66% value of all claims secured by that asset. इसको एक बार फिर से समझ लेते हैं. इसमें बहुत सारे सुप्रीम कोर्ट के भी जजमेंट्स हैं, कॉन्फ्लिक्टिंग जजमेंट्स भी हैं, एनक्लेड के भी हैं, that there are multiple secured creditors who are having security interest in one particular property. अब I am having first charge, you are having second charge, then there has been a very great conflict of interest, and if you are realizing your dues, I am becoming the dissenting financial creditor in the process. So I was losing my several rights into that. Now the position has been clarified. It will be discussed in the COC. The distribution mechanism, realization mechanism will be finalized in the COC, and it will be approved by more than 66% value of all claims secured by data. Value of all claims secured by data asset. This is important. Not 66% of the COC. 66% value of all claims secured by data asset. तो उस एसेट में जिन जिन लोगों की सिक्योरिटी है उन लोगों के वोट चाहिए 66%, पूरे सीओसी के नहीं चाहिए. As per this, now we have to see the final code because it is under finalization by the ministry. Secured creditor as unsecured, section 53. If value of relinquished security is less than total debt owed, creditor is a secured creditor to extent of security value and unsecured creditor for the remaining debt. IBBI to specify manner of determining security interest value. This clause is already present in the IB code, but now the IBBI has to specify that how the security interest value shall be calculated, shall be determined. This is the change. So it will also provide safeguard to us. Next, please. Guarantor asset transfer, new section 28A. A creditor who has taken possession of a guarantor's asset by enforcing security may transfer it as a part of the corporate debtor CIRP subject to condition. Presently, what is going on? We complete our CIRP or we complete our liquidation, but my dues are not paid off in full. Then for the remaining dues, I was invoking the corporate guarantee. Then I was filing the PIRP application, and we all know that there has been no development in PIRP applications. Banks are also fed up because there has been no recovery, nothing, and they already disposed their assets and everything. There is no look back period in PIRP matters. So now this is a very welcome change. Even though that asset doesn't belong to the corporate debtor and it belongs to the guarantor, then the bank who has enforced the security interest, they may transfer it to the corporate debtor CIRP. I think that it is very clear. My friends would have understood. Standard case, creditor has security interest over guarantor's asset. Creditor has taken possession by enforced security. Transfer permitted with COC approval. Corporate debtor COC. So if COC approves that, okay, you have taken possession of the guarantor asset, you transfer it to the CIRP, no problem. Corporate guarantor in CIRP liquidation, additional approval from corporate guarantor COC. More than 66% vote. If liquidation only required where asset relinquished to liquidation state under section 52, amount forms part of CG, CIRP or liquidation state. Now, what is there on that particular asset belonging to the corporate guarantor? There may be other creditors, and those creditors may or may not be in the CIRP. But for that asset, for example, I have taken my housing loan. It has no concern with your CD and anything. And that is HDFC Bank, for example. So, and few of the members are also having security interest into that guarantor's asset. So that COC when initiated in PIRP, so that 66% approval has to be taken separately. Approval from majority, 3/4 in value of PG's creditors, amount for part of PG's insolvency bankruptcy process, surplus over debt paid to the guarantor. तो आप इसको CIRP और लिक्विडेशन में ट्रांसफर कर सकते हैं. After transferring, we will realize it, and if the debt is less than the security amount realized, then such excess shall be paid to the guarantor. ये नहीं है कि आप पूरे सिक्योरिटी को, it was done basically to curtail the processes and period adopted by the financial creditors in realizing the guarantor's asset in SURFACE or any other thing. Because CIRP is a time bound process, liquidation is also a time bound process, and SURFACE, DM permission, and then recovery agent, and then DRT, then DRAT, several things are there. Once it is transferred to the CIRP, every process shall come to an end, and RP will realize, and with the approval of the guarantor COC, own CD COC, and then if excess is received, then excess will be given to that particular guarantor. Voluntary liquidation, Section 59 reforms. Timeline added. Voluntary liquidation must be completed within a period specified by the IBBI, not exceeding 1 year from commencement. In voluntary liquidation, previously timeline was not there. Now timeline has been prescribed. Termination has also been prescribed. New mechanism to terminate voluntary liquidation. If the resolution has to be passed by the members, creditors 2/3 in value approve within 7 days is company has debt. Liquidator intimates IBBI and ROC within 7 days. Here NCLT is not mentioned. Deemed termination from the date of intimation to the ROC. So again the NCLT and taking permission for termination, just like section 12A in the CIRP, when it is approved by the NCLT, then only it is terminated, but it is not in the proposed scenario. There has to be a special resolution. If there are creditors, they have to approve by 2/3 of the value, and the liquidator will simply intimate to the IBBI and ROC within 7 days, and immediately after information it is deemed to be terminated. Registered valuer. Report of valuation of company asset must be prepared by a valuer registered under section 247 of the Companies Act, not just any registered valuer. There has been already a notification 4 years back, 4 or 5 years back, I think 4 years back, that only IBBI registered valuer can value the asset of the CD, but now they have specifically prescribed in law. Claim verification clarified. Section 59(6) amended. Reference to Section 18 claim collation inserted. Omission of Section 3842 does not affect liquidator's power to verify claim and determine their value in voluntary liquidation. So 3842 has been omitted. Section 38 to 42 has been omitted, but it does not decreases the power of liquidator to verify claim and determine their value in voluntary liquidation. So liquidator has to perform his duties and role into it. Can I take 5 minutes break? Friends, do you permit?
Sure, sir, please.
Yes, sir. Yes, sir.
Yes,
sir,
we do.
please take. So we can also take
Thank you,
5
sir. Thank you,
minutes.
sir. Thank you.
Thank you.
Friends, should we start?
Yes, sir.
Yes, sir.
Yes, sir.
Thank you. Thank you. Thank you very much. Actually, previously, when I was council member in ICMAI 11 to 19, and I was also chairman, उस समय खूब प्रैक्टिस थी बोलने की, different different conferences, programs. But when we came in the project management in IBC, so we could not find time. 3-4 घंटे लगातार बोलना, अब थोड़ा सा ब्रेक चाहिए होता है बीच में. Sorry for that. So now, friends, we are coming to the individual insolvency, part 3 reforms. What are the reforms? Personal guarantor interim moratorium exception, interim moratorium provision of section 96 don't apply when an application is filed in respect of a personal guarantor to a corporate debtor. There has been a very interesting case. What happened that we had filed avoidance application under section 66 in liquidation, and in the meantime, one bank initiated personal insolvency against the suspended directors. So application was filed. So the opposite side argued before the court that now there is moratorium, and from where you will recover under section 66 or avoidance, it will be recovered my personal assets, and there is a moratorium because my PIRP has been initiated. So how you will recover? So that 66 should not be entertained and should be dismissed. We made a robust argument as per provision of law because it is not related to debt. And in the meantime, there has been enclate order also. And we filed that order and fetched order in our favor. So section 66, the PIRP doesn't preclude section 66 because section 66 is not related to debt. It is related to, as per definition, it is related to the wrongful act done by the suspended board by alienating money of the corporate debtor. So now they have completely abolished. There will be no moratorium when you file application. No repayment plan, automatic termination. If friends are having book, then they may refer, and several we are facing problems at several benches also. I would request to kindly refer section 106. There has been, they say the section 105 talks on the repayment plan. That is clear, repayment plan. And then section 106 says the resolution professional shall submit the repayment plan under section 105 along with his report of such plan. Now consider that no repayment plan has been filed to you despite your best attempts. So previously in the law, there was no provision to call creditor meeting or COC meeting. The provision was only when you receive the repayment plan as per regulation 17 of the PIRP regulation. Okay? And you received the repayment plan, then you were issuing notice calling the creditors meeting as per section 1063 and read with section 107. So that was the process. Now PIRP is initiated, correct? I wrote to the personal guarantor to give the information so that I may prepare statements of affairs as per regulation. He did not provide any information. Then I was given liberty to file non-cooperation application. And the entire process has to be completed, filing of the repayment plan within 120 days. Process has to be completed in 180 days, but repayment plan process has to be completed in 120 days as per PIRP regulation. Now neither I received any information from the personal guarantor, nor he filed a repayment plan. Now, what option was available with me? I cannot call creditor meeting. After some time, there has been amendment in PIRP regulation. Just I think 6 or 8 months or 1 year back. So that amendment provided that even if you do not receive the repayment plan from the personal guarantor, you have to call creditor meeting and notify to the creditor that no repayment plan has been received. Previously, we were sending communication mails only that we have not received the repayment plan. Now, when you did not receive the repayment plan, under which section you will file your closure report? That close the PIRP and initiate, not initiate, so that the lenders may file, creditors may file application for bankruptcy. There was nothing. So what we were doing, we were filing our report under section 106, wherein proviso gives, because this problem might have been faced by by our few friends also. So under which section we file our report? Because there has been no repayment plan, and Act says that creditor meeting shall be called only when repayment plan is there. Now amended. So bench was asking that you filed a report under wrong section 106. You should have filed under section 1112. What 1112 says, that the resolution professional shall prepare a report of the meeting of the creditor on repayment plan. So when a repayment plan is not there, how can I file my report under section 112? This was the problem. Then section 114 says order of the adjudicating authority on repayment plan. That is the closure. So there is a catch, and that you have to narrate. Whenever you don't receive any repayment plan, kindly file your application under section 114 proviso, read with section 106, because 106 provide 106 subsection 2 proviso, provided that where the resolution professional recommends that the meeting of the creditor is not required to be summoned, reasons for the same shall be provided. So you record the reason that I did not receive any repayment plan, but quote that section in Allahabad bench. We missed the mentioning of section 114. So hence amended prayer was filed into that. So always file under section 114, read with section 106. You will file your report under section 106. Now this position has been clarified. Now if no repayment plan submitted within stipulated period, RP must submit report to learned A. A shall then terminate insolvency process. It is not present in today's laws. Debtor creditors may then apply for bankruptcy. So that is there. And now it is clear. Bankruptcy application expanded. Section 121. Bankruptcy application now also permitted where A has passed order section 1061A terminating the insolvency process. Presently it is not there. If the insolvency process, no repayment plan is received and insolvency process has been terminated in case of personal guarantor, then the lenders were not having authority to file the bankruptcy application. So that has been amended, that is good. Extended examination period, section 99. RP now has 21 days. Previously it was 10 days only. To examine application filed under section 94 or 95 and submit report to learned A. Report copy must now be given to both debtor and the creditor. Although we were giving the report copy to both, to the creditor and debtor, but now they have specifically mentioned, and now we are having 21 days time to file our report under section 99. Section 1063A, personal guarantor mandatory meeting. When repayment plan concerns a personal guarantor to cooperate debtor, to corporate debtor, RP must summon meeting of creditor by issuing written notice specifying date, time and place of meeting. ठीक है. Even though if you don't receive the repayment plan, you have to call the creditor meeting. That is the PIRP regulation has been amended, and you have to notify to the creditors that we have not received any repayment plan. Bankruptcy initiation exception. Bankruptcy initiation provision of section 124 don't apply where application for bankruptcy is filed by a creditor or debtor in respect of a personal guarantor to corporate debtor. Section 124 भी एक बार देख लेते हैं क्या है. When application is filed by the debtor, that is section 122, and section 123 when application is filed by the creditor, this is with respect to bankruptcy. And 124 says effect of application. When an application is filed under section 122 means by the debtor, or 123 means by the creditor, then an interim moratorium shall commence on the date of the making of the application on all actions against the properties of the debtor. So now they are saying that 124 don't apply where application for bankruptcy is filed by the creditor or debtor. तो ये मोराटोरियम वाला जो है ये कॉन्सेप्ट ही खत्म कर दिया है दोनों से. ठीक है, थैंक यू. आगे बढ़ो कमल. Penalties enforcement and disciplinary framework. Our IP friends will like this reform, long awaited reform. Previously, what was formation utility, insolvency, professional agency, and other service providers. If there had been any disciplinary proceedings against them after so-called notice, they were allowed to file appeal to the Honorable and CLAD against the order of the IBBI. But the same was not present in case of insolvency professionals. Insolvency professionals, if they are facing disciplinary action, there was no appeal mechanism at all. They were required to approach only to the High Court in writ. Now, there has been a very good reform into that. Section 64A, new section has been added, frivolous proceedings. 1 lakh up to 2 crore penalty for initiating frivolous or vexatious proceedings before learned A under part 2, means CIRP. Section 235A, substituted. General contravention penalty. Per day rupees 1 lakh of continuing contravention. Maximum 3 times of the amount of loss caused or 3 times unlawful gain, whichever is higher. Cap if not quantifiable. If quantification is not possible, then 5 crore. A may reduce below rupees 1 lakh per day with written regions. 183A, new frivolous proceedings. Rupees 1 lakh to 2 crore penalty for initiating frivolous or vexatious proceedings before A under part 3, individuals. Section 220 amended. Disciplinary committee powers. Penalty ceiling raised from rupees 1 crore to 2 crore. Officers not below executive director rank can be members. Previously, GM, AGMs, DGMs, everywhere were issuing the orders. So-called notice referred to disciplinary committee. So-called notice were being sent by the IBBI directly without referring to the DC. Now it will be DC. Appeal to NCLAT within 30 days, extendable by 15 days. This is a very welcome step. At least our friends shall be having liberty to say their grievances if the proper procedure are not followed or records are not properly seen, then they may file appeal to the honorable NCLAT. In all the institutes, we are having disciplinary mechanism. They are also independent professionals. Disciplinary committee is totally independent from the management of the organization. And I think that Honorable IBBI will also look into that. So that DC is totally independent from the IBBI. IBBI expanded powers and service providers. Service providers have been defined now: insolvency professional agency, information utility, and any central government notified person. Previously, as per my memory, I may be wrong also, insolvency professionals regulations were totally different and they were kept out of the service provider. Unified regulation is there now. All references to individual entity type IPA, IPIU replaced with service provider. जो पहले इसमें रिफर करते थे कि IPA, then IP, then IU, then RP, IP. Now the definition is changed. Now they all will be called as a service provider. Throughout section 196, 217, 218, 220. Single regulatory framework. Previously, the regulatory framework for the IPs, now the single regulatory framework is there. Fee levy clarified, IBBI can levy fee charges for all process under the code. वो तो पहले भी था उनके पास. Information authentication. Corporate debtor must authenticate information submitted to information utility. If no response is filed, then it will be taken as a deemed authentication. Operational creditor must submit into before filing section 9 application. मतलब इंफॉर्मेशन यूटिलिटी को एम्पावर किया है कि आपको यू हैव टू फाइल योर क्लेम अमाउंट टू द इंफॉर्मेशन यूटिलिटी, और immediately after filing the claim, information utility sends mail to both the lender and the borrower for confirmation of the debt, and they have to confirm, then it is registered. And now they have specifically provided if within 30 days it is not communicated or no information is sent, then it will be deemed as a authentication. Operational creditor must submit into before filing section 9 application. उसी को भी अब ये information utility पे register करना पड़ेगा. COC standards. IBBI now empowered to specify standards of conduct for committee of creditors and its member while acting under part 2 and part 3, मतलब CRP and liquidation both. So it is a very good. We were facing several issues with the COC. Different temperament persons come, and the most important problem is the person participating in the COC is not the decision maker. Decision maker is some different authority or authorities. So now if there will be a standard, then it would be very good for all of us, for the smooth functioning of the CIRP and liquidation. Purpose-based rule making. Both central government under section 239 and IBBI section 240 can now make rule regulation for purposes, not just provisions of the code, broader mandate. So central government has also been empowered. Actually, whatsoever regulations are made, it is approved by the ministry always. So now it will not be oriented to the must be a defined purpose of such amendment. Why that is required? Electronic portal, new section 240B. Central government can provide electronic portal for insolvency and bankruptcy processes. अब सेंट्रल गवर्नमेंट आपको इलेक्ट्रॉनिक पोर्टल प्रोवाइड कर सकती है टू रन ऑल दीज प्रोसेसेस. So that we have to see. Next, cross-border insolvency. Section 240C. Central government empowered to prescribe rules for administering cross-border insolvency proceeding for notified classes of debtors and corporate debtors. I remember one of my case. What happened that the PIRP, personal insolvency, was initiated by SBI, and I was appointed as RP. That case was a very big case. And after 3 months, the personal insolvency was initiated in the Singapore court against the same person because he was having few assets in Singapore. So the personal guarantor informed me. Then we filed our representation, appeared before the Singapore court, and said, submitted our Indian NCLT to them. And after considering all reports, they terminated that PIRP in Singapore and said that you have to file your claim to the RP in India, where your PIRP is being commenced. Now, what is difficulty in cross-border insolvency? That if government is having an agreement with the different it is enforced. It can be enforced. For example, will we consider order passed by some London court here in India, or that has to be validated by our Indian court? Yes, it is possible, provided there has been agreement in between government to government. There is agreement in between government to government of Nepal that your Aadhaar will not be considered there. They will consider your passport, your driving license. At one occasion, I missed my flight because I was having Aadhaar, not driving license or passport. So for that, and now the entire world is performing as a one unit. So global alignment agreements are being made. So many developments are taking place. So cross-border insolvency is a very welcome step. So global alignment, law foundation for protecting domestic and foreign stakeholder interest, aligns Indian practices with international best practices. So that is there. Parliamentary oversight. Draft rule must be laid before both houses of parliament for 30 days before notification. Both houses must agree to any modification or disapproval. Okay. Designated benches. Rules may designate one or more NCLT benches for dealing with cross-border insolvency proceeding. Specific benches may be designated for that purpose. Investor confidence. Enable recognition of Indian insolvency proceeding in other jurisdiction and recognition of foreign proceeding in India. Boosting FDI confidence. That what we discussed. There has to be agreement कि हम आपका ऑर्डर मानेंगे, आप हमारा ऑर्डर मानो. Flexible rule making. Rule में modify provisions of the IBC and Companies Act with exceptions, modification and adaptation as required. So it will require modification in the IBC rule and Companies Act rules also. Difficulty resolution. Section 242 amended. Central government can remove any difficulty arising from implementation of Section 225 amendments for up to 5 years from commencement. Even after Act is there and some difficulty, practical or other operational difficulties are being faced, then the same may be addressed by the central government up to 5 years from the date of such amended IBC code. Expected impact and benefits. Judicial burden. Reduced via creditor IRP out of court mechanism. So it will benefit into it. Resolution speed, standard CIRP 330 plus days. Now the creditors IRP 150 days, 195 maximum. Asset value recovery, value erosion due to delays. asset की वैल्यू ही खत्म हो जाती थी डिलेज की वजह से. Faster resolution, higher asset value in the new regime. Creditor protection, dissenting FC, minimum unclear. Split minimum payment formula. Now the minimum payment formula has been devised. Transparency, limited RP liquidator oversight, enhanced via COC supervision of liquidation. Given powers to supervise the liquidation and CIRP process carefully and help the RP or IRP. Liquidator appointment, RP auto appointed as liquidator on recommendation of COC. Now after amendment, COC proposed, board confirms, RP disqualified if plan rejected. ये important है. मान लीजिए क्रेडिटर मैकेनिज्म में if your resolution plan is rejected, then you are automatically disqualified to be appointed as a liquidator. Automatically disqualified. Plan नहीं आया, that is a different issue. But if plan आपका reject हो गया, तो you are automatically disqualified. You cannot be appointed as a liquidator. Look back period counted from insolvency commencement date, जो avoidance application है 43, 45, 66. Now counted from earlier initiation date, filing date. Section 47 application, only undervalued transaction, only creditor member partner can file, and only undervalued transactions were covered. Now all avoidable transaction plus wrongful trading, joint applications are also allowed. That a creditor member and partner, they may file jointly in case RP fails. COC role in formal supervision role over liquidator during liquidation process. Voluntary liquidation, no specific timeline, no termination mechanism is present as of now. And now maximum 1 year new termination procedure via special resolution has been prescribed. Withdrawal section 12A, applicant consent was required. That we discussed earlier. RP applies with 90% COC approval. Applicant given hearing only in case he desires. He intervenes. अब उसकी consent की जरूरत नहीं है. Fraudulent trading section 66. Only RP could apply during CIRP. Liquidator may also apply during liquidation process. Now liquidator is also empowered to apply during liquidation process. अब conclusion, the IBC amendment key statistics 150 days maximum creditor IRP timeline, 180 days liquidation target completion, 66% COC vote for key decisions. That is already there. 90% COC vote for withdrawal. Now there has been 68 substantive changes across the code. New creditor IRP out of court initiation mechanism has been introduced. Group insolvency and cross-border insolvency frameworks have been made. COC supervision extended to liquidation process. Clean stale principle codified in law. Enhanced protection for dissenting creditors made. Streamlined timelines with accountability mechanism. expanded service provider regulation under IBBI. So this is an broader overview of the IBC amendment bill. Naturally, when bill will be passed, we hope that in this session, commencing from 9th March, it may be passed. Then we will come across the entire nitty-gritty of all the amendments, because whatsoever I have told you today, it is as per a draft sent by the IBBI Parliament. Then a committee was formed, headed by Honorable Jagdambika Palji, and that committee has sent certain recommendation to the IBBI, and now the IBBI is seeing all these parameters. So there you may find certain IBC code after the bill is passed. But more or less, we could gather the intention behind all these activities and intention of all these things. So we are very much thankful to you for considering me and giving patience hearing into it. Uh, if you are having any doubt on our IPE also, Shreya insolvency, so we are dealing with several assignments. So if you are having any doubt or any query, or you require any assistance, we are having a different legal team with us. And we have a compilation of orders, good orders, and several orders have been faced, which has changed the history of IBC by our arguments. And we are thankful to all the stakeholders for their cooperation. ICSI and their IPA for awarding us an opportunity to deliberate on the issue. We shall keep on meeting on different subjects, and you may refer to my YouTube channel also for recent updates. So thank you very much, and now I hand over to the ICSI officers for further processes. Thank you.
What's a very nice summarization of the entire discussions. You have made very nice summary of the changes, very useful. Can you share this PPT with the participants? Or
Yes, sir. We have already shared to the IPA officers and
Hmm.
ICSI, and they may share it to our friends.
Yeah, thank you. A very nice summarization. Thank you. Well done.
Thank you, sir. Thank you very much for motivation. Thank you, sir. So over to the ICSI.
Thank you, but sir, before the ICSI come, I also wish to thanks you a lot because you have given a lot of insight on new regulation which is about to come, and really it will help a lot of IPs to think new directions ki how the resolution on a corporate or personal can be achieved as fast and as different way.
So
Correct.
kind of you.
Correct.
Plus, government is working in different ways to ensure ki the regulation which has come, which can be how it can be improved to actually get a solution, a resolution to a corporates and individual. Thanks
No,
a
I
lot, sir.
think, but sir, it will require more deliberations, at maybe at institute levels, or maybe, at the professional levels, or
Yes, sir. Yes, sir.
various fine points, like creditor-led IRP process, the new
Yes,
one.
yes.
I
Yes,
think there's
yes.
a new chapter, and it will require more deliberation and more thoughts to be
Naturally,
shared.
sir. Naturally, sir. When the this amendment comes and
Uh,
new rules are made, definitely we
uh,
shall be deliberating in detail into
mm.
each and every parameter.
अब
But sir,
इंस्टीट्यूट लेवल
Sharma
पे कुछ
ji,
करो.
sir, but sir, Sharma ji, then whenever new laws come, it comes with certain expectation, and it needs a certain deliberation as well. So I also say कि हाँ deliberation will be required, And anyway, it will be for a positive
Yeah.
because we will be able to see
Correct,
what of
correct.
insight of the new regulation.
करेक्ट सर, करेक्ट सर।
और व्हाट्सएप इंस्टीट्यूट लेवल पे कुछ करिए ना,
ठीक है सर, वो भी करवाते हैं वो भी
उसमें
करवाते हैं।
कराइए इसको, आराम से
जी।
बोलिए, करेगा कुछ ना कुछ।
ठीक है, बिल्कुल बोलते हैं सर, करवाते हैं इसको। जी जी, करवाते हैं सर।
ठीक है, आई थिंक आईसीएस वाले चले गए कि शी गॉन एंड स्लीपिंग।
We should call it completion of this session.
Yeah, I think so. I think so. Thank you, sir.
Thanks,
Thank you.
Sharma.
Thank
Because
you.
CP
Thanks, Paliwal ji. Thanks.
Thanks.
CP hours is also there ना, so they
हाँ,
have
उसको
to.
बताना जरूरी है उसको।
Yes sir, yes sir.
Yes. Okay, sir. With your permission, we'll leave this presentation.
Thank you, sir.
Thank you.
Thank you.
Over to the ICSI IPA.
Yes, sir. Can you conclude now?
Yes ma'am.
Okay. Thank you very much, sir. The session was very wonderful. Thank you very much, all the participants. Also, you want to give valuable time and attend this session. Thank you very much, sir.
Thank you. Thank you. Thank you, dear friends. We will keep on meeting.
Yeah,
Thank you, sir.
thank you.
Thank you.